afternoon and good evening to everyone, wherever you're tuning from. Welcome back to another episode of the Service Conversations, a space where we reflect, we question, learn and explore the evolving world of justice in the legal profession. Today's episode is one that every law student, every young lawyer, every educator and every practitioner who has worked in the long corridor between law school and the right of legal practice would want to be part of. This is a conversation that the entire profession continues to hustle with, because where the legal education provides us with theory and several principles and the foundation, when reaching the courtrooms, boardrooms and chambers and probably dealing with clients, everything seems to change. So for years, this meanwhile, also law firms are saying the lawyers coming out of law school are not ready to handle whatever is brought to them from the academic world to the demands of practice. So today we are privileged to have someone who understands this journey both from those sides, because he teaches the law, practices the law, and invests.
Thank you. And for those who are not accustomed to judicial service conversations, our first question is always the same. And our first question is about you. People who are joining want to know, who are you and what makes you tick? They want to know about Emmanuel Meta Aloro. What is it that makes Meta?
Thank you. This is an interesting conclusion to the question, what makes me boil? I'll probably say if Arsenal were to win the Champions League, I would boil. But as an advocate, I have enjoyed the privilege of practicing this noble profession. And I got into practicing law, not for your usual reasons that everyone else gives, that I want to practice law because I want to do ABCD. I dodged the mathematics class in primary 3. I started failing math, and so I looked for a particular course I could be able to do that would not involve a lot of mathematics, and I was told it was law. So that is where the journey began. But along the way, I have developed passion for the profession, because once you decide to do something, you do it seriously. Now, my journey took me to University of Dar es Salaam, where I was tutored by very eminent lawyers and professors in Dar es Salaam into the practice of law. So when I returned to Uganda to begin the Law Development Center, I realized there was a lot that I did not know when I left university, and I was able to get part of it from LDC. But then along the years, maybe that was 2008, 2009, in about 4 years, I realized I had started to forget certain aspects of practice. And I also then realized for the first time that it's a very competitive field, that you will not just be put things on the silver platter. I think that's when I started to ask myself the question that every young lawyer and every other lawyer is asking: how wide is this profession? How far do we go? What is available out there to be done? And that pushed areas of practice which really you could make your name out of. Because if you stand out there and say you want to be a criminal law expert and you want to do criminal defense, you're going to find the colleagues who have 30, 40 years of experience, and they have done it very diligently ahead of you. So you must be able to craft that niche or that space. You have to be able to grow the profession into different areas. And that's what keeps me awake and thinking every single day, that where do we go on from here? So the passion for the law, for me, comes from the fact that the law is dynamic. The law is not static, and it makes you a dynamic human being as well. Because I'm sure 10 years down the road, whatever we've taught at the bar course this year will more or less be foundational knowledge to be relevant for the practice of the time. So if you're not dynamic and you think you're going to practice the way we've practiced today, you may as well give up on the profession. So for me, that is what keeps me boiling, and that fire comes from the fact that we have to keep changing and innovating and thinking. would say that is what really takes me down that route.
Thank you very much. You said that you failed mathematics, and that's what drew you to the profession. But I know I'm aware that although you failed mathematics, you know how to count money. So, but you see, you've said interesting things there, and I think we want to.
People are starting to think outside the box. In the last few years, you will realize that the minimum share capital requirement for a bank in Uganda has gone to 150 billion. And a lot of people are up in arms, said it was too high, and Ugandans were being locked out of setting up commercial banks. But if you look at 150 billion, and look at maybe the cost of putting up a facility or an investment like Bujagali or Karuma, that is the entire share capital of a bank in Uganda tenfold. Because if you look at $300 million and you can't raise $30 million, then there's a problem. So what is driving us is the fact that out there are people who have the capital, auditorium to be had. But no, that's one of the things you have to be able to do if you're to command some bit of discipline in a large audience. But it's a question that is now, I think, very hot for discussions currently in the legal fraternity. There have been several proposals in terms of how the whole thing can be looked at. But from my perspective, and if I pick your question correctly about legal education but also skills, I think let's begin with the skills. But also ask yourself, if you, the client, if you, the advocate, for me that is where I think the cloth should be cut. You've had questions where people have said, if you push your son or your daughter through medical school ecosystem where every single education provider is accountable. Because you'll find it hard to one path old way that we used to. So that means a lot through one path old way that we used to. So that means a lot through the system, and they are not actually giving them the knowledge, then you can have a lot of problems. You can imagine there are some people, and I'm glad we have several listeners who have joined us, but I'm sure among them there's that one person who has never opened a case law book to read a case from cover to cover. They have relied on handouts and summaries. Expect them to analyze the facts and think the way those who prosecuted the case thought, and it's not possible. Now you bring on board AI, where I can plug a case into a system and it summarizes it, makes things worse. So the knowledge issue is going to become a problem, and I think National Council for Higher Education should be called out on this. They are the ones who give the licenses for those who are going to teach law, but also I think the parliament should be called out on this. They don't give them enough of a budget for them to be able to run that docket effectively. Maybe because they have a lot of people there who are distant from education, and they can imagine if senior six is your only competence to join the house. I don't know how you're going to give National Council enough money to police universities. So that issue is there. But I think the skills really will come down to the change in market. Lawyers need to be dynamic. The skill that we need to teach should be the skill that can make one adaptable to the changing situations. Because you can see now we have, let's say, the prosecutors at the Directorate of Public Prosecution prosecuting cases based on forensic evidence. None of them studied forensic evidence when they're in undergraduate, I'm very sure, because there was nothing like that. But they have been able to adapt and be able read into that entire space, and they're able to move. So that is going to be the most important skill of an advocate in the next few years, because they are going to compete with artificial intelligence. But also, an advocate must have integrity. We have serious integrity issues in our profession. A lot of people say, this lawyer took my money and he did not do the work. In Lugbara, there's a saying that when you go to fetch water from the well and one frog jumps into the water and makes the river dirty, you don't fetch water, you go home and say the frogs have made the water dirty. So that is a problem. So I think integrity should be a serious issue. But when you ask about the legal education in Uganda, I think we should not only look at LDC, because LDC has now become sort of a sieve for everyone who comes from all these private universities. So National Council really needs to do its part in making sure that I've been involved in universities that are trying to license to teach law. The requirements are quite stringent, and even the requirement, the caliber of lecturers you're supposed to have is quite stringent. But then the question is, once you're licensed, who is going to follow it up to make sure that you said senior counsel ELISON KARUGANGA would be the one teaching legal method? Is he the one in class? Or his CV is used to ensure that we get the license, and then you bring someone else to come and hold out, which someone else does not have the competence, does not have the qualifications, and is unable to deliver that which we perceive should be delivered. So once we can fix that problem, then of course we can also look at reforming how the law is taught at these universities, but also at LDC, because there might be instances where we are still teaching in 1990. So we need to be able to see these dynamic areas, because I believe the challenge is we are teaching lawyers to come and compete in a world of the past. The future will cut them out. So we need to teach dynamic lawyers. The skills will really need to evolve around understanding. And even in my classes, those who have been in my classes, I think there are times when I tell you, I usually call it house cleaning or housekeeping. Say, once you're done with the back course, go and do a course in computer something. Because at the end of the day, you're going to advise people and defend people who are going to commit crime online using these gadgets. So let's understand that space and be able to understand where business is going and it's developing, for us to be able to be relevant to the clients.
Yeah, thank you, Mr. Meta. I hope my internet has now become dynamic. I've also become dynamic to catch up with it. And when you talk of dynamic, there's someone who's very dynamic with us here. He's been cross-examining people on guns as if he has ever used the gun. So I can imagine. But yeah, thanks for this conversation. And from my end, you cannot have an honest conversation about bridging the gap between the legal training and practice without talking about the state of the bar course, because year after year students raise concerns about the bar course generally, the lion hunt, the cost of pursuing the course, the teaching and delivery methods. I think you have even commented on them somewhere where you're noting that we are still training maybe lawyers to practice in an area which we no longer practice in. So we are teaching we are teaching tomorrow's lawyers practice in yesterday's legal practice, which is long gone. And so they complain of the nature of assets and overall the relevance of the bar course to the real world practice. So these concerns are not new. They are very persistent year after year. They're always being talked about. So from your 360 view of the legal profession, both as a teacher and a legal practitioner for quite a number of years, what is the central idea behind the proposed LDC reforms, and what exactly are those reforms seeking to fix? Thank you.
Well, the question of LDC reform, Alfred, thank you. You've been there and you've seen it. Because when you talk about a reform, a lot of people would want to see changes. I believe the ideas behind reforming the whole LDC and the bar course and in a large way the legal professional training comes down to the quality that we expect to deliver out there, and that quality is the quality of the lawyers. Now, a lot of people have said, LDC is a monopoly and it's congested and there's too many students fighting for the same seats. A lot of people have said, it's costly to run the course. Of course, that might be beyond the students. But also, people have complained that, the quality of lawyers today, I think that's a general comment that if you ask any serious senior practitioner out there or businessman out there who engages lawyers, they will tell you the quality of the lawyers today is not at the level of what was there before. So once you start having those comparisons, and in the comparison the dinosaur comes out on top of the current breed, then you have a problem. I don't see people saying that the efficiency of the Mercedes car of 1970 in Formula 1 was better than the one of 2025. So in tech, something is being done different. Why is it that the generation of lawyers we have today is not? So you have classes where you have, we've tried to reduce the numbers from 50 to 40. Now I think it's about 25 to 30 students in a class. But you can still imagine that's a huge number. So to get the payment that you would get from winning a dispute against the Attorney General for compensation of 15 billion shillings. It will never match. You could probably teach that for 30 years and you may not get what someone could get in one payment in a serious commercial transaction. So do we have enough skilled lawyers who are able to go to all these universities, first of all, to teach? Then two, if LDC were to be decentralized, would they be able, or would the institutions that are going to offer this particular service be able to match what our senior colleagues in the profession are saying has been a downward shift in terms of the competence and quality of the lawyers, which will come down to ratios, which will come down to the quality of those who are delivering this. Now, if you look at LDC as a teaching institution, 90% of the lecturers are part-time lecturers. They're not permanent. So you can imagine someone who is there and is part-time and he is delivering this kind of training, then at what level of input do you expect him to give you? I'm sure if all the part-time lecturers at LDC said we're not teaching today, LDC cannot run a single teaching day. But if you're a teaching institution and your core mandate is teaching, and you're run by part-time lecturers, then there's a question of priorities, I would believe. Because there should be a budget that these guys are going after teaching. Now, that is why when you go to the students, you ask them, you'll find the students have all sorts of ratings for us. There are those that will rate you very, very poorly. There are those that will rate you excellent, depending on whether they like you or they don't like you. Now, a lot of my colleagues there put in the time, but you can't have enough time when you have to balance between you walk into a class, you find a group of 5 students who are well prepared for the class, they have read their workshops and they're ready. Then you find another group who are seeing the workshop for the first time. Now, at what level do you take the class?
I was usually in that group.
of the latter. Now, you see, you can risk being in that group if you're able to catch up very fast. But if you're asking questions and the questions are clearly indicating that you have not really read the workshop and you've not appreciated the basics of what is being taught that week, then you're going to have a problem. Because at the end of the day, the lecturer will leave class and will leave you behind. And LDC is really, it's a marathon, but it's a marathon done in the fashion of a sprint, a relay. Because from a corporate week, you're going straight into land. So whatever you did last week has nothing to do with that you're starting this week. And next week, you're moving into family law practice. It has nothing totally to do with land. Then you move into civil litigation, and you move into criminal. So if you lose a week, you're done. Now, you talked about assessments and the teaching. We've tried to improve on the assessments and reduce, because students were saying they are overly assessed. And the Law Development Center has gone well into trying to reduce assessments. That's why the curriculum review was done, to first of all lower the number of subjects which were there. Because at some point in time, I think we numbered over 12. So we've maintained the 5 core, and then you have another group of 4 which are all compulsory. But even in assessments, I think maybe for this exceptional year, we have just 2 IAs, individual assessments, being examinable. The others will be peer reviewed. Whether it's a good thing or a bad thing, hopefully we shall have a report by the end of this year to see the impact and whether it has improved. But when you look at the way the assessments are done, a lot of students still have the mentality that these are like coursework that you're doing in secondary school, which do not really mark towards your final exam. The individual assessments in LDC are final exams, because they contribute to 20% of your final mark. So doing 2 individual assessments should not be considered as if someone is being over assessed. But that is an issue. Then of course, when you look at the teaching methods and the relevance, we have pedagogy trainings, but I think they need to be more frequent. We could have them more frequent because there are those who have better teaching styles than others, but also it's difficult to have one teaching style when you have dynamic students. So that dynamism might be important for you to be able to see. We have our student-centered programs where the students are supposed to make presentations, but at times I have to delve in. I talked about the day one advocate earlier. One of the key things I said they need knowledge, they need skills and values. When we talk about skills, we are looking at 3 things for that student. 1, are they able to comprehend? They read facts, they read a problem, are they able to comprehend what is required? 2, are they able to synthesize? Synthesis is important. When you look at it, you look at the law, are you able to marry these 2 together and come up with an opinion which is legally valid? And then of course, lastly, analysis. Now, for you to have all this, when you have a group that may not have the knowledge, it's very difficult for you to jump the knowledge gap and go straight. So the teaching method might need to, in the meantime, blend this. Because we can blame the universities all we want, but you only work with what you have. And these are now your students. And that's why when people fail, naturally as humans are, they will blame the Law Development Center and say, you're failing students, you fear competition, A, B, C, D. All those words will be, hurled at us. Yet you put in your best effort, but you're working with someone who is taking forever to appreciate. So that is there. But also, if you look at LDC, for me personally, I think one of the biggest problems of LDC is rumor mongering. Students come when they have been lied to by the predecessors so much that you think you're going for a military training in Ukraine or in Gaza. Because someone tells you LDC is impossible. They have given it all types of names for the acronym LDC. Others say, Low Depression Center, LDC. So all these things are because you see that someone has told you it's difficult. But if you went there with an open mind and you're willing to learn, I think the institution is set up for you to learn. And if you look at the assessments being done with the IAs, the individual assessments, it gives you a chance to test what was in that week. So really, if you're taught one topic in a week, and then you have a test in that topic, and out of 10, you prefer to score 2. then the problem might be that either you attended the wrong class or you are not attentive at all. Of course, there's other issues that come in, how the paper is set and all that, but at least that should be focused enough if you're going to practice law out there. Then of course, you also look at oral exams. There's oral exams and for me, I've always borne the school of thought that oral exams are a bit difficult for the simple reason. If you appear before a difficult panel, and humans are difficult by their very nature. Someone may just walk in and you find a panel that has been annoyed by the previous student who has really, made things bad. And one of the panelists may end up asking you a question which might be inappropriate. That may not be the case, but also the nature of questions asked. If you find a seasoned practitioner like my senior brother ELISON, he would ask a question from a very practical point of view. Then you find an examiner who is not as senior, he may ask a theoretical question. And the student will be very happy with the theoretical question and get it very fast. Then the one who has a problem question from an experienced advocate that expects you to apply your knowledge and come up with a solution might say, I was maliced. So the question then is, as we have meetings before these orals to try and balance and say it should be this way and that way, but with 2,000 students, 1,500 students, there will always be the one. Even us as examiners at times, you get on a panel, someone asks a question, and you're wondering whether the student is going to be able to pick it. The answer is very clearly in front of the student, but the student overthinks to the level, starts telling you things that you don't even believe and appreciate. But so all those you can see are instances where the Law Development Center might need to adjust, especially with orals. I really think it gives students a chance to express themselves, because at the end of the day, it's a profession where you speak. If you're unable to speak to your peers, what are you going to, what we are testing in orals must then be different from what we are testing in the written exams. We must be testing the skill of communication of an advocate. So that should also maybe carry some bit of weight. So when you talk about reforms at LDC, when we talk about the need for it to be relevant, it should be that, because at the end of the day, two lawyers will go to the Supreme Court and they will argue, and one will lose. And then who loses will also be a senior lawyer. The justices of the Supreme Court will give a decision. 2 or 1 will dissent. That one is also a senior judicial officer. They do not stop practicing. So it's not wrong to, it's not bad to have a contrary opinion. The unfortunate part is when you have a contrary opinion at the Law Development Center in an oral panel, then we don't consider yours as a dissenting opinion. We consider it as an incorrect opinion. But maybe such a person should be commended for maybe standing by their point and being able to argue it out if it has any logic. So the teaching methods for me will come down to how many people, maybe such a person should be commended for maybe standing by their point and being able to argue it out if it has any logic. So the teaching methods for me will come down to how many people can we lower the teacher to student ratio. If we can't lower it, regardless of whether LDC is phased out and you have the national bar exams done, and they look at the teaching ratios at the universities. Let's look at Uganda Matters University. Let's look at IU. Let's look at KIU. All these universities, I doubt there's a single university where the student to teacher ratio is below 10, like the LDC of 1980. So we must also accept as a legal fraternity that we're not going back there. And it's lucrative for the universities that are teaching law. So unless there's a deliberate government policy that is going to say, let's lower the ratio, I don't see the problem of numbers being solved by procrastination. I don't see that problem being solved by any possible reforms of the Law Development Center. For example, saying let the universities teach. At LDC, we are complaining about the universities. At the profession, you complain about LDC. So everyone is blaming someone. So where does the buck stop? Who is going to bear the legal burden of trying to undo all this? So you can see that a lot of research is going into trying to reform, and that's why recently we reformed the curriculum. We had a curriculum review, which I felt was very, very important. Certain course units were taken out, some new course units were introduced, and I think that is LDC responding to the market out here, that we need to look into certain spaces where, and also if you look at the subjects we've added or the course units we've added, corporate and commercial, for example, students are now back to doing insolvency. At some point in time, it had been taken out. Now we are back with intellectual property. At some point in time, it had been taken out. These are areas where you can be able to develop a niche. But then, how do we deliver it? That is going to be a very difficult question for us to answer. But the calculus of it is that LDC, with all its students blaming lecturers blaming students, and vice versa, I think at the end of the day, the middle line has to be drawn that this is a profession, and LDC is really, really a sieve to try and see who is the best and most deserving of the group to be able to come out here and practice law. But it should also be able to offer a chance to every single child or student who has offered themselves to practice the law. Thank you.
Thank you. If you're just joining us,
You are muted.
if you're just joining us, welcome to the Judicial Service Conversations. I hope you can all hear us and our sound is doing well.
It is not.
Welcome to the Judicial Service Conversations. We're having none other than Emmanuel Meta Aloro, who is firing on all cylinders, explaining everything with the wit, clarity, and persuasion of a senior advocate that he is, and a senior practitioner, and also someone who has thought much and given much to legal education. Colleagues, you've heard the advocate of the future, the day one advocate must have knowledge, skills, and values. I can tell you that I know a lot of 1,000 advocates who also need to start getting some knowledge, skills, and value. Some of them, am I allowed to say this? Some of them are on the bench. But anyhow, so some of them are on the bench. So I agree with you. You know, when I joined LDC, there's a senior colleague whose name I will not mention. He was a fantastic teacher. And on the first day, he told us that the Law Development Center is action-packed. If you intend to be a flower girl, forget about it. We are here from Monday to Saturday. Some of you, he told us, are so dense that I will give you a certificate of title and ask you who owns this piece of land, and you will tell me 0.5 acres. He told us that some of you are so dense, you shall find yourself in oral practical exercises, and the thing shall be so tough. Some of you, he said, then I remember when they were teaching, I don't know if it was at LDC, maybe it was at the university, somebody was teaching about a topic, they called it contract. It was in contract law, and they were saying, what rights do third parties have? And so the teacher asks the students, what rights does a person who has not signed, what are the exceptions to the doctrine of privity? That's what us lawyers call it. For those of you who are not lawyers, that is, the contract is between the two parties. If you're not part of them, you have no benefit. But what are the exceptions? And so people said, well, so the teacher then asks the student, if, for example, you go to a shop and you buy a gift for your girlfriend, and she gets it and she doesn't like it very much, and she wants to take it back and get the money, and he shares the receipt, can the shop give her back the item? And the student said, of course it can. And the lecturer asked, legally, why? And the student responded, there is no way the shop can remember that she's not the one who who bought it. So sometimes the practical and the legal, they can mix in a way. You can the practical answer may be the wrong answer. And the man was sent out of class for being practical. So I think it's a fantastic conversation to have about really who the future lawyer, the future of the law. And so I think we shall give the next question to Alfred. But if you're just joining us, welcome to the Judicial Service Conversations. I can see a good number of lawyers, and I can see a fair number of practical law students here with us today. But over to you, Alfred.
Thank you, Mr. Elison and Mr. Meta. Talking of the fair number of the practical students, when you talked of the Law Depression Center, they were like, by the way, Alfred, we need to leave this Law Depression Center. And Mr. Meta has been doing us a good service since teaching the service since second term. From all rows up to now, at least we know we are still on the meta list. But yeah, but we still want to maintain being on the meta list. But we are the students who take forever to appreciate. So you should hand us in that line, because we hosted one person last time. Sometime Mr. Kazaru told us that I can guarantee that I'm going to lecture you, but I can't guarantee your understanding. So maybe those who take forever to appreciate, for you do your part to teach, but you can't guarantee them appreciating. But though you just want to talk those who take forever to appreciate, but they are sent and they want to live as early as yesterday. But they are still, yes, that they are still on the meta list as of now. So they are looking for those exam tips for backward students, because they have tuned in quite a number. They could be in almost 200 on call now, but they are practical ones. So, and for passing the backwards, so that they leave the Law Development Center as early as yesterday, what they be? Maybe just in addition to those who have been giving, or those who have not been reading, they can get those tips.
And maybe for the uninitiated, us the old lawyers, you can tell us what's the meta list.
Okay, LDC, when you excel, you get on the director's list.
Yes.
So I tell the students usually that we all can't be on the director's list. The pass mark is 50. With 50, we can all be in the tent and graduate. But even if all of us were to score excellent over 80, the ones who would be on the director's list would be maybe 99. The ones that get 199. So the director's list is, tied down. So Meta's list is what students coined, that Meta's list is a list of students whose target is 50%. They have to get 50% and get out of there. All they have to do is graduate. They don't want to know about your list of the director. They don't want to know about being the best student. They are there to make sure that in the worst of days, they score half, 50%. So that is basically what the students call Meta's list. But the exams are coming, and I believe the students have been preparing. And I've been telling them that, actually I told them during orals that after orals, they will never be as smart as they are. After orals, it's a downward turn in terms of how brilliant you are, because when they prepare for orals, these kids prepare like they want to overthrow the United States of America government. They don't sleep, they ask questions, they discuss, and they will know everything in the core subjects: family law practice, land transactions, civil litigation, criminal proceedings, corporate and commercial. They will know everything. They will know the laws, they will know. So the question then is, where does that hard-working, brilliant, focused individual go once the orals are done? Because once orals are done, they go to default settings. Default setting is, we are going to finish. The sun will set. But during the orals, they are extremely brilliant. So what I've been telling them is, bring back that focused individual for one more month. One more, and you get done. Because that person who was there during orals is good enough to pass the bar course. This one that you've brought now, who has replaced the exceptional guy, is going to let you down. So, what are the tips that you could give a student who is going to undertake their exams? I think one, they first of all need to understand that these are practical exams. Look at all the questions, and I'm glad a lot of them are looking at past papers to see how a question is set. And I always tell them, when you read that question, imagine you're seated in your chambers and the client has walked before you and is narrating to you a story. Let's take, for example, in an election season. Let's imagine it's an election petition, and the loser has walked into your office and is telling you a story. And the person who has won, did not have the requisite academic qualifications, there was ballot stuffing, and tells all these illegalities and irregularities. When they are done and they say, help me, are you going to start telling him what is an election petition and all the hallmarks of a proper democratic election, and then you tell him to go home? How is that going to help you? What is going to happen is you have to tell this guy that from what you have told me, I'm able to take your matter to court and file a petition, and you will succeed. Now, how you do that should be at the back of your mind. So the same thing should happen in an exam, because you can't answer a question and then don't offer solution to your client and think that you have taken the question full. So that's one thing. And it comes down to question interpretation. Ideally, for a profession as ours, if you look at how assessments are marked at LDC, you have the internal examiners and external examiners, and you have all the verification and all those things, which basically means that even in developing the marking guide, you're going to have 2-3 advocates consulted. The only reason I can confidently consult another advocate about a question paper is if I know that the question is framed in such a manner that the answer is plausible, that any advocate with a similar level of knowledge and skill can see through and know this is what it is. And that is the skill that students lack. And that's when I talked about a day one advocate, I talked about comprehension. Are you able to read that question paper, internalize it, understand it, and know what is required? Once you do that, it's an open book exam. The procedure, you've written it out in your exercise book. The documents, you have them in your book. All you need to do is really, edit here and there, and you have the document done. So for me, that is one important thing that students must have at the back of their mind. Be able to appreciate a question, look at the traps the examiner is setting, the leads the examiner is giving you, and be able to link it to the law, and then offer that answer. Two, students must learn to manage time. As an examiner at LDC, I always tell students that I believe personally that if, let's say, we had 100 students, hypothetical, 100 students who have failed the bar course. Of those 100, about 60 have not actually failed. They are just unable to finish the exam. They did not actually write wrong answers. They wrote so slow that when they said time up, he was starting question number 2 when the time is done. And you could see that when you mark question 1, this student is good enough, because you can assess someone's competence just by looking at how they're thinking in one event. But then they don't finish the assessment because they're either writing too slow or they're thinking too slow, and that's where the problem is. So time management becomes an issue. So managing time and being able to allocate the requisite number of minutes to marks is important. If you see a question that has 5 marks, why should you write for 20 minutes? For me, 1 mark, 1 minute. So 5 minutes, you should answer that question 5 minutes and you move. Otherwise, you'll end up writing so much you write 3 pages for a question of 5 marks. Then you're really not there. Others even go to the extent of drafting a document for a question of 5 marks. That means you did not interpret the question correctly. So that is important, that you must manage time and conclude and complete that exam. 3, have organized notes. Recently, the policy is now that students, it's not mandatory for you to have handwritten notes. We had a policy where students were forced to have handwritten notes, so that if you go into an exam, you must enter with your handwritten notes. You're not allowed to photocopy someone else's notes. Now that policy has been adjusted. I recently saw a tweet, I think it was by one of the students, that Uganda is a very, very backward place, because who tells you that you should now go get a textbook and transfer the notes from the textbook to your own exercise book for purpose of exams? What kind of world are we living in? And of course, that's such an interesting statement, and it makes you laugh. But you hand out questions and say start, and the first thing the student does is pick the handout and starts looking for the answer in that handout. That is wrong, because nowhere in your book are you going to find the same scenario. You need only consult your book. If you're going to look at maybe the format of a document, if you're not conversant with it, you're going to look at maybe a detail of a procedure, and maybe the holding of a particular case, or the full citation of the case. And I always remind them, from P1 to P7, you had closed book exams. S1 to S6, closed book exams. In the universities, you had closed book exams. Then LDC, that head which you trusted so much, from P1 to university, you now discard it, and they say it should no longer think. Once you begin the exam, you pick the book and say, where is the answer? And that is where the problem is, because then you stop thinking and you start looking for the answer in the book. So have organized notes and know what procedures you have. You know, for example, when you dealt with second term, I tasked all of you to outline all the procedures and all the documents you find in all the different subjects. You have those notes. Now do the same with term 4. But when you get into the exam, only consult your book if it's necessary, because you lose time. Imagine someone is drafting a plaint and you know it is in the High Court, Land Division. But the moment you start drafting, even the Republic of Uganda you want to copy. You first read the Republic of Uganda and then you write Republic of Uganda. Now, what kind of speed are you going to really finish? You can't finish. There are certain things that should really now be with you. You should back yourself as an advocate and be able to draft these documents. All right. And then lastly, my last advice to you is mental health related. Some of you now, you're dreaming about us pulling your pieces of paper away from you when time is up. They've started dreaming. I see some of your statuses, some of the family leaders are friends. people are posting all sorts of, nightmares about exams. It's because, one, you don't get enough rest. Whether you like it or not, this exam will come and go. So it would only be a fool to say that, I need to stay awake for 22 hours. I'm going to sleep for 2 hours. On the day of the exam, when sleep comes, sleep has come. Sleep doesn't have respect. You sleep in that paper, and there's nothing you'll do about it. Why? Because you chose to tire yourself to a point whereby you're not ready for the exam. So rest, apportion your time. Wake up in the morning and say, today I'm going to handle corporate and commercial, for example. And when you're reading corporate and commercial, don't read it to cram sections of the law. Read it to understand. For example, if you look at week 1 of corporate, we talk about setting up businesses. So visualize yourself and be able to tell yourself that when I'm reading corporate and commercial, I know what a limited liability company is. The procedure for setting it up is in my book. I'm not going to read it. I know what a single member company is and the circumstances and instances in which you're going to make it. I don't have to read about the procedure because I can copy the procedure. Now this is really, I tell them this is a hustler's version. Have an idea so that when the question is being set, you're able to pinpoint that this is the area I'm going into and I will be able to deliver based on the fact that I know I've tagged my book and it's there. So that when that time comes, it's okay. Lastly, you're going to do exams and you'll be about, all the campuses are coming to Kampala. So that is Mbarara campus in Kampala, 2 intakes. Mbale campus, 1 intake in Kampala. Lira campus, 2 intakes in Kampala. Kampala campus, 2 intakes in Kampala. Previous year students and those doing retakes in Kampala. And you're supposed to be there by 7 a.m. And the exam begins at around 9. And then you will be finishing at around 1 o'clock if we begin on time. And then, of course, with your numbers, when you collect those scripts, you might leave the exam venue at 2 p.m. Food is not allowed in the exam room. So I don't know what you're going to do to intestines to be able to work it out. We've had this discussion, I think, with the guild, and I think they are trying to talk to management and see what to do about it. But you can imagine the logistical nightmare that you're going to have to canvas. So if you're going to be that student who says, for me, I stay in Namuongo, 30 minutes can get me to LDC, even if you're using a bike. You'll get there and you'll not find a seat. You'll get there, you'll find the place disorganized. And those small things can put you off. So follow what is being told. And don't risk. Students are very daring. There will be that one fellow who's going to enter that formation, and you have a phone in a pocket. And unfortunately, it will be one of those, the parade. And it will ring in your pocket. And that is it. And you've taken a risk, which is a huge gamble, and you get discontinued for something unloyally. So let's really prepare and get there on time. The exams are going to be there for 3 hours, and in those 3 hours, you should be able to back yourself. Do not rely on people who are going to, because some of you will rely on your colleagues. You're going to have seat numbers, and I'm sure AR will give a very detailed guidance. But if you used to sit next to Alfred in Kampala campus, and now you're sitting next to Otim from Barara campus, you may not know whether Otim knows or he doesn't know. So if you risk by looking into his book, and you get other things which are not correct, then you'll have yourself to blame. Back yourself and go, because at the end of the day, once you pass this course, when you're seated in your chambers a year from now and your senior counsel tells you to interview a client, you're not going to call your family leader and put him on loudspeaker. And now the client is here, what should I ask? He has told me his name. Should I tell him what a cause of action is? That's not what you're going to do. You're going to be confident. And I always give them a simple example. In all your villages, they call you council, just by finishing 4th year. And when the village people tell you a particular problem, you're able to advise and you're correct. Now, for some reason, if it's an exam, you don't believe in yourself. So it's really that kind of confidence that you need to have in yourself, but it comes down to how well you prepare. 2 weeks is a lot of time, but also a very short period of time. If you've not been doing anything, if your business, I've been tweeting and telling you, when it rains, don't cuddle. go and read. But some of you tell me that, the problem is you talk late. Now I've talked early, and my senior brother is here, he has heard. At least we put you on notice that any rain that comes from today until 13th, that rain is not for cuddling, that rain is for you to read. But the rest of you, you run and do funny things, and you think that it will. We're not going to set about, well, family law practice may set about, things related to consummation, but that is not how you prepare for it. It's not about the practical. It's not like a biology exam. They're going to say, come and consummate your paper. No. They're going to ask you questions and you must know, theoretically. So prepare best as you can. And I believe that having done 4 years in law school and gone through the Law Development Center for a whole year, you should really be, up to speed. And it is really up to you. The ball is in your court. It is your fate. It is your future. And the legal profession is waiting for you to join. I'll be happy to see you as colleagues, and we run the streets of Kampala and the Arua and Mbarara together. But this stage must be passed. Know why you went there. It should not be, a case of the pot breaks at the entrance after you've carried all the burden. Thank you.
Wow. That was very insightful. As Joy tried to get back to ask a question, I don't know, the network is not being dynamic. For those who are, at least everyone now is assured of the matters list to be on. Not to brag, but I was lucky to be on the directors list, and I can relate to most of the tips.
You on the directors list?
Yes. I was not on his list, but I skipped his list. But I used still the same tips. At least I can concur with most of them, especially for the thing of not risking to copy, and the things of when you talk about relying on others, you reach a room and you say formation. You'll have the whole group having the wrong remedy, and yet you had your right remedy. So trust yourself. Then, at the issue of managing time, I usually tell my colleagues that 2 fairly done numbers are better than 1 best done number. So each number is 2 hours. The moment it reaches the 2-hour mark, whether you're done with that number or what, you rather go to the second number and do something there. Instead of spending 3 hours on one number, then for second number you do one hour on that number. You won't do anything, and you really can't. Then for the preparing for the exam, as if you're going to do a closed book exam, because if you don't do that, you may reach the exam and you revise from the exam, and time will be spent in that regard. And for the drafting things, you can't keep copy and pasting everything. So by now you should be able to draft most documents offhand without going back to the book. Otherwise, you may even copy and paste the name of the parties and you end up filing in a wrong code. And with regard to mental health, you get enough sleep. You need to have a refreshed brain in that exam hall instead of an exhausted brain. Those I can concur the tips. So maybe with those tips for the matters list and from me what was the directors list, we can have a combination. We are there in the middle of that list, and we will have most of us or most of our colleagues leaving the so-called low depression center. I think now Joy is able to get a network, or the network is not being dynamic today. I'll first hand over to Mason as we saw the network issue. Thank you.
If you're just joining us, we're having an interesting conversation. I think we're talking really about right now the challenges of young lawyers who are sitting at the bar exam. And we have none other than Mr. Emmanuel Meta Aloro, who has the Meta list. And the Meta list is the just make it over the finish line. Just finish. You know, that LDC, they told us, is an open book exam in many instances. And I think Meta has told us that from P1 up to the degree, you are doing closed book exams. What happens to your head when it's open book? That open book thing messes with your head. You see, just imagine a guy allows you to come to an exam with notes. That is a guy who is so sure you're going to fail. So you will be able to fail properly, because really, what kind of thing is that? Then the idea that you shouldn't cuddle when it rains. I don't think that maybe let me not comment about Catholic. I mean, but I think that I don't know if students have any time to cuddle, because all these things that you are saying, I think when they come out of the exam room, sometimes it has really rained in the paper. You finish answering a question, and you realize that the issue was that the guy was not, you hadn't seen age. You know, someone gives you a crime, and you realize that the guy was below 18, and you realize that when you're walking out of the exam, you understand the question better. So I think there are all these issues, and I think it's important for our listeners, especially those who are not at the Law Development Center, or those who don't have exams right now at LDC, or I think these sort of conversations are important, because what we are discussing here is an immediate challenge to someone who will be in the future. Because what Meta said at the beginning is something that I think should be seen properly and identified properly. That in that class, there is a future Chief Justice, there is a future Attorney General, maybe there is a future Judge of International Court of Justice. Who knows, maybe there's a future Head of State of Uganda. And we may not have an opportunity to honor them or to advise them when they are that important. They may get there and hang us or injunct us, whichever the case may be. And so I think at the Judicial Service Commission, my lords in that class who have the exams, we are much obliged to you, my lords, and we are here specifically. We are much obliged to you. So I hand over to Joy. I think Joy is on now.
Thank you. Technology is playing me, but we'll work it. Council, you mentioned something about the period after oral exams. Now, in our defense, that period is really fresh in my brain, because I just came out last year, by now, just to put it out. In that moment, I think the brains are wobbly. You don't even know what is happening, what time, if you're dressed or not. I think we just show up because of that. And I remember also the PAs or the professional assistants or teachers, for our listeners that may not get the PA thing. Some of them would also be tired. Like, I remember some instances, especially in the afternoons, they enter class and say, by the way, we are also tired. You look tired, you know, like you stand at the front and everybody, like the aura is just exhaustion. Get over with this. People's hair is not combed. Then the suits, the shirts are really creased. Like, you're just showing up because you're showing up. You're on flight mode. And so you mentioned that, and I just remembered, because, man, after orals, you just don't know what's going on. And so the PS would also come and say, you look tired. By the way, I'm also tired. I don't have the time to be here, but I'm showing up. So let's get it over with. You know, next year we're going to have people who are looking fresh and are happy to see us. So I think from the students' perspective, that is literally what is going on. We are literally exhausted and burnt out. But I think, like you mentioned, we don't have to be deflated. We just have to keep going and keep the momentum. Now, my next question is about AI. And I think that we've been saying that AI is the future, it's the future, but I feel like we are living in the future. It's already here. And so it's about the mentality and how we embrace it or lean more into it rather than out of it or freak out, because people feel like, okay, now why am I studying law? You know, do we even have jobs out there after this? And I know you've talked about it in reference, because I wanted to just find out what skills we should have to stay competitive, especially in the era of AI. And I know in the conversation, you already mentioned some of the skills. And so I don't know if it's part of it, maybe you'll expound. But to just re-echo, you talked about knowledge, you talked about adaptability, to changing situations in order to stay competitive, and I think you tied it to AI as well. And you talked about integrity, and then you also mentioned about reforms and all that. So is there any more that we need, or would you expound on this so that we stay relevant in an era of artificial intelligence? Over to you, Council.
Thank Thank you, Joy. Just, one thing on the previous question from Alfred on exams. You must also learn to compartmentalize. When you get into a corporate exam and it has knocked you, don't go to your room and say the world is done, and then you end up messing the next paper. So learn to know that for this particular one, it has gone, and let me focus on the next one, because you're better off. At the very worst case scenario, failing 2, you come and do your supplementary, as opposed to failing all 5, and then you have to, in the current system, apply for pre-entry and begin afresh. So that's important. Now, Joy, you asked about AI. AI is now, I think, a big disruptor in every single field. Take the banking industry, for example. The development of fintech, the financial technologies. The banks are now competing with the telecom companies in terms of banking, or what we used to consider banking services. Now the same thing is going to happen with our legal profession, because I think I saw an article, I don't know how true it was, that there is now going to be a robot judge in India, or magistrate, that can handle simple matters. If you look at what most young lawyers used to do, it used to be research. You'd get into chambers, go and look for authorities here, draft these submissions. Now, artificial intelligence can do that. Simple letters. I recall when I was at Lex Uganda, one of the senior partners gave me a letter to draft, and one day advocate, I drafted my letter, and he looked at it, he wrote so many things on it, said go and change. I changed, came back. I was up and down the whole day.
One letter.
In one letter. And then 4 days later, I looked at the second draft I did, and I felt it was okay. That's the one I took back to him. And he said, now you see, you've learned. This is very good. I know this is the second draft you brought, but I just wanted to know whether you're resilient enough to stick to it, or you're going to get angry that I'm trying to guide you. You can no longer have such a scenario in the current era, because someone is going to draft something, put it into maybe Perplexity or Chat GPT, and have a perfect document, and then just make a few edits here and there. So AI is on its way, and I agree with you, Joy, entirely that we have to embrace it. So the skill the young lawyer must develop today is to understand how to make these tools help you. Technology has always been there to help man to do things better. Okay? Running, from running and walking to driving and flying, all that is to aid. But whether we like it or not, technology is here to stay. So if we are going to be a profession that is going to be relevant, we have to be able to embrace it. You will be surprised that there are law firms out there that to date do not even have conferencing facilities, and you still have to have physical meetings. Now, if that is your practice, it's going to be very difficult, because I believe in a few years we shall be able to license virtual office spaces where I don't need to have a physical address. For example, if you license a law firm in the year 2000, you needed to have the physical red and blue volumes. Now, law council is not insisting on those if you have soft copies. Now, even the universities are going to adapt. If I'm going to set up a university that is to teach law, all I have to demonstrate is I have online material. So even the students will begin to adapt from there. I recently challenged my colleagues and said, why don't we are marking individual assessments. I said, but students keep complaining that I was marked badly. Why don't we just do this? Set exams online. One, to do away with cheating. Have the persons who are going to set the exam convene at for example, now we begin exams on 8th. Let's have the people who are going to set the exam arrive at 7 in the morning, sit and set the paper. All the students take their seat in front of a computer or a tablet, and the paper is uploaded at 9. And in 3 hours or 4 hours, the computer shuts, or your tablet logs you out and shows you your marks. So if you have 10, you go home knowing you have 10. If you have 80, you go home knowing you have 80. No bias, nothing. That's where the future is going to take us. But then, of course, you have to look at the competence in terms of there are people who can't even type a letter on a computer yet. Now, it is not that because life has disadvantaged you, you should accept it. Some of us, I was chased from a computer class in S1, and I was told to go and do agriculture because that is what I was good at. And I passed. I passed my agriculture. Because they told me to turn on the computer, I didn't know where the on button was. Everyone turned theirs on, and I looked at mine, it looked back at me. And the teacher thought I was joking. I said, but you man, you know that I was in Arua Public Primary, and I came to Rubaga Boys, I was in a boarding, I don't know anything about computers. Man said, leave my class. I said, okay. And I did agriculture because it was an option. I don't know what informed our teachers then that computer was an option, and the alternative was agriculture, but it worked for me. Now, the students must embrace artificial intelligence because that is where the world is headed, but it also creates new opportunities. Because I don't think, with all due respect to our senior colleagues who are 40 years into practice, that they are going to sit and try and understand artificial intelligence now. They are really planning for their union with Jesus and Muhammad. So I don't think someone who is above 75 years has any business to trying to understand fintech and technology and all that. But that is going to be where we're going to litigate. And even those who want to do criminal law and the rest, crimes will be committed online. The world has become a global village, and AI, whether we like it or not, is here to stay. All these fintech and developments in terms of artificial intelligence, generative AI, they are going nowhere. Of course, I recently saw the CEO of Google saying that when that bubble bursts, every single tech company that has invested heavily in it will have an issue. But I don't think it will burst to the level that will take us to 1990. It will burst in terms of value, and valuation of these tech companies, but that is where it is going to be. And even if you look at the banks, now if you advise a bank, for example, with the legal office of a bank, and the banks are now working with certain AI tools and things like that, to sit and negotiate such a contract and even talk to the staff about it, you must understand that space. So for the students, I think once you're done with your back course, you need to go and at least do a small course or something that is related to understanding the current trends and where we are headed. Otherwise, you will be considered a dinosaur in this profession even before you have 2 years of practice. You might end up practicing nowhere. Now you look at there are lawyers who can't even upload documents on ICMIS, so they will not know that where the case is moving. So such small things, they have become a necessity. The same way cell phones have become part of us. AI is going to be a part of this profession, and it should challenge us to be better. It should challenge us to be better versions of ourselves, but it should also be able to guide us in terms of where we are moving, and should make our lives more comfortable. So let us embrace it. Let us not wait for it to be imposed on us by other people. Let the lawyers be the one to take a lead, and a lot of the young lawyers who are listening, this is your field. It's your peers who did computer science who are the ones disrupting the world with this particular area, not the guys who did computer science when my senior brother ELISON was in Makerere University. Those ones, they used to do Microsoft Word and antivirus. These guys now are on a totally different trajectory. So you should be able to relate to that more easily. Thank you.
Thank you, Council. I don't think we are aiming at becoming dinosaurs. I think you've had it like that call that after LDC, it's important that you interest yourself in getting out there and studying something that is in one of the trending courses where the world is going. And I think I've also mentioned it, we've also mentioned it here before, that there's an article that was released that talks about the future of jobs, and also this is the area I'm also taking you into the next question. So in some of the jobs that are going to be extinct, or some people that are really going to lose jobs, lawyers are part of that. So that means that you need to not just study for the sake of, I'm a lawyer, I've graduated, and you feel good. I usually say that kuground bidala muko, so you have to have something that sets you apart. Now on to the employment bit, Council. There's fear definitely that there are too many lawyers, out there at the end of the day. I think you've said, what's the number now at LDC? 3,000. Okay, so now imagine a given percentage. I will not say the particular numbers. So a given percentage, a huge one of that is rolled out. And even before the current year, so you also rolled out in the numbers what sets you apart. So people say there's so many lawyers, but there's not, the jobs are not equivalent to the number of lawyers that are being rolled out. And so from your experience and from the knowledge that you share with the students, what are some of the opportunities that actually exist in the market, and how can young lawyers position themselves to be able to meet those needs? I think some of it is what you've mentioned, getting interested in AI, but probably there's more knowledge that you could share with us since you have experience in the field.
Thank you, Joy. I'll just answer this in about maybe 3 ways. One, if you look at the current job market, indeed, we have a lot of young lawyers who have graduated, and they want to be part and parcel of the current work list of employees in the legal sector. Now, let's take government. Of course, we've had these arguments at Uganda Law Society, and I'm glad that we have senior colleagues here as well. If you look at all the police stations in Uganda, those who do investigations are not lawyers. Why can't we have a policy where every single police station has maybe 2 advocates who are able to advise? Because if you look at issues of investigations, that is law. So why do you have someone who finished senior 4 and has done some funny training do all this stuff, and then you end up passing the burden of perusal of files and things like that? So those are reforms that a modern police force should have. But also the other areas, the land registry, you find that brokers do more transactions than advocates. You go to the company's registry, we have registrars who are not lawyers, they're not advocates. So you end up filing a special resolution instead of an ordinary resolution because an unlearned fellow who is at the seat there has told you so. But because you want your company to be incorporated and you want to do certain works, you end up doing it. These are fights which, as a society, Uganda Law Society, we should be able to take up. Some of these initiatives were started. I don't know what has happened, but that is one area. 2, the young lawyers must think outside. It's not a must that everyone who graduates from the Law Development Center should go to court, should work as something. There are times I tell students, why don't you set up an NGO? I'm glad one of our listeners is Nicholas Opio. Set up an NGO. That space is there. You can do more work with public interest litigation and things like that. And you don't need to go and beg for employment at a law firm. How much does it cost to set up an NGO? A company limited by a guarantee and an application to the NGO bureau. And then you run it from your father's garage. You don't have to pay rent. Okay? When you have a high-profile meeting, talk to your colleague who is working with senior counsel, ELISON, go and plead and say, can I have a meeting in your boardroom? Have that meeting. But you're doing something. There are other futuristic areas. I've met a group of brilliant young guys at the Law Development Center in this past term who are looking into things like carbon trade. Now, this is an area that is totally virgin. Very few people understand the concept, and you wonder why and how they went into that space. But the opportunity is there. So there are green fields which are there. Okay? Now, we only say that there is no work for lawyers if you want to stick to the same traditional work. For example, if you graduate now and you think of becoming a company secretary, most of these companies now have in-house counsel, and they also litigate. So that work is also taken away unless you become an employee of the company. So I think it is really high time that we started thinking about new areas. Whereas we may all want to work in a law firm, but the other spaces. Look at all the musicians who are singing. How many of them have their intellectual property rights protected? We can't say. Look at sports. We have a league here which is as old as the country almost. But how many of those footballers have lawyers? How many of them go into sports agency? Some of the best sports agents are advocates, are lawyers. So why don't we look at such areas and be able to position ourselves into a totally new field? You're not going to compete with senior counsel Mark Dusman Kavega or Caleb Alaka for instructions to defend someone who has been accused of a crime. They have the pedigree, they have built the name. Now, for you, a 2-day advocate, you've just got your PC. It is even green. It's not even a normal color. So you're not even sure whether you should even go to court and how to even behave. But in the area of carbon trade, no one has more than 10 years experience as an advocate in Uganda. I don't think there's any advocate in Uganda. If they are there, they're not more than 2 who can say they have experience in trading carbon and advising on how to do it, let alone even drafting contracts. So those are fields that students should be able to embrace and move into. Insurance, it's a growing area. Even tax, I went back into tax. But if you look at tax practice, when we are reforming the curriculum in LDC, I came across a very interesting piece of research, and I think you guys can Google it for yourselves. The biggest 4 audit firms in the world make more money than all the top about 50 law firms in the world combined. I was shocked. PricewaterhouseCoopers, Deloitte, Ernst & Young, KPMG. Look at their total revenue globally in a year. Look at the top 50 law firms in the year. Those guys dwarf us. What is the bulk of their work? Tax. There's nothing else they are doing. They're advising on tax. But you look at it, what came first? The numbers or the law? The law came first. So a good tax practitioner should appreciate the law. When there's a dispute, we end up in court, in the tribunal. The accountants and auditors don't go there. But we are so worried about numbers, we want to know how to count what we've earned. So until we're able to take those brave steps and move into areas where we can go and disrupt other professions, like the accountants and auditors in tax, then we have a problem. They may not give us work of audit, but we shall be able to litigate. And as long as the government keeps needing more money, they'll keep taxing more. And the more they tax, there'll be more tax conflicts. So those are areas where we could be able to develop business. So there's a lot more, but it's all about trying to understand what are the needs in the market. Being the first guy to do it is not a problem. That's why I was telling you, I was impressed by a young man at LDC who is looking at carbon trade at a level that I had not even envisioned myself. I'm very interested in that space in terms of climate change and all that. But this young man has gone so far ahead, and it's astounding. There's another young one, Luis. I think Luis has done a lot of work in Bitcoin and cryptocurrency. We didn't teach that at LDC, but he has gone out there and learned, and he has learned that there's work there to be done. So we need to use the law to our benefit, and I think that's why they call us land fellows. We're called land because initially, if I'm right, to be a lawyer, you needed to have another degree. You need to first have done something, then you go and do law. So I don't know why we keep stopping to study. So you, the young generation, you should be able to go and study further and look at other areas and expand this market and do law as a business. Because what I've realized is most of the law firms operate like a kiosk. Most of the law firms operate like, it's a small kiosk, and you go there and you're back out there. When the managing partner dies, the law firm closes. Very few have the corporate structures in place. But you, as a lawyer, you should be able to practice law as a business, because the biggest challenge we keep hearing is that young lawyers are not being paid. That discussion is a debate for another day. But if the senior counsel doesn't have money to even put fuel in his car, how can he pay you 2 million shillings a month? It's very difficult. So you must be able to think outside the box and, be able to pull your own weight. But there's enough out there. Look at what is happening, maybe South Africa, Nigeria, Europe, for you to be able to see where this profession is moving to. Don't get stuck and listen to stories of when I graduated from LDC in 1980, I was appointed to work in the Attorney General's chambers. Now you advertise 4 jobs in the Attorney General's chambers and 2,000 people apply. So they picked you straight from school and you went to AG's chambers. And you're now telling me I'm unserious because I'm not getting a job in Attorney General's chambers. Some of our senior colleagues have that kind of misdirection at the moment. So, but it only means that you, the young lawyers, are not also thinking hard. You want to behave like you're modern, but in real life, you actually act like you've been in the practice for 40 years. So think outside the box. It is not a must that we should get stuck with going to court and advising here and there. Corporate finance. Come up with a model that can work. Most of the young guys here are now trying to develop apps. Work with them. Own a share in that app. Advise on how it can be properly, registered and protected. And you move on from there. So I think the lawyers should be more ambitious, and maybe in corporate and commercial we should have a course unit in terms of business development for a law firm or for a lawyer, or what opportunities are there. Thank you.
Thank you, Meta, and thank you for, if you're just joining us, welcome to the Judicial Service Conversations. We're about to reach the end of the conversation. I think there are a lot of tips which have come through, great ideas, things which, about the jobs that are coming up, the nature of the new economy, about how you can be part of the profession. Before I hand over to Alfred, I've received a question because you spoke about Nicholas Opio, and I have actually gotten a question from him. And his question is about health, and someone else has said as well, I think also Nicholas, but someone else has said that you have what they call Mike Tyson muscles, and that you have well chiseled biceps. Now, then there's a lady who has said something which I'll not read here. Okay. I don't know what she was triggered by. I think it was that cuddling jazz you had brought here. But they say that maybe that's why your mind is as sharp. So they want you to speak to this issue. Many lawyers waste away in unhealthy practice. In some quarters, drunkenness has been held as a lawyer's trait. And I'll just say a few things about drunkenness. I'm not making any confessions. But alcohol, of course, is a big issue in the life of lawyers. I saw, and has always been, I saw a tweet from a general of the EPDF who is also a lawyer. I think it's General Sejusa, who said that when he was at law school, his lecturer, the late Kiapi, asked them to go and study how many people had been convicted under the Nguli Act. And the Nguli Act had been there for 12 years, and now the class went on a research to establish how efficient was the Nguli Act. And they found that the Nguli Act, nobody had ever been convicted under the Nguli Act. There had been an attempt at prosecution. According to the general, there had been an attempt at prosecution. So they studied what happened in this prosecution. And they said that the problem was with the exhibit. Once the Nguli was confiscated, the accused person was charged. Half of the exhibit was drunk at the police station, and the rest was drunk by the court clerk. So by the time the matter reached the magistrate, there was no evidence. Of course, they also felt that the court clerk had probably taken a fall for the prosecution. So there's certainly in alcohol has been associated with the profession in a big way. And so there's I know colleagues who, anyway, let me not say, but the question on health, first of all, and the glorification of alcoholism of alcohol within the profession, and also the question of health. Does health keep you sharp? I think is a question we're getting from our listeners.
Thank you to our listeners who are asking questions. Nicholas, thank you. I think we all have to agree that when you're healthy, you work better. Because I usually ask myself, what is the cost? What's the opportunity cost of doing fitness vis-a-vis drinking? It's okay to drink, but do you have limits? there's irresponsible drinking where some people don't know their limits. They drink and they don't know when to stop. And the health impact might be dire. If senior counsel expects you in chambers tomorrow morning and you have a serious matter coming up and you spend the whole evening drinking, chances are, even if you woke up and you made it to court, you'll not be at 100%. And once that becomes a trait, you'll never really reach the level that you would be able to reach in terms of that. So I think everyone has to find something that keeps you busy outside the law. But for me, fitness is part of it. If you have a long day, you go to the gym and carry some weights here and there, you meet a totally different audience. The music is different, the people are different, the jazz is different. It resets you. You listen to different people's problems. At times you may get clients there. At times you find people who have more problems than you. So there's going and you think you have problems, then you find someone who is really, really in trouble, and you're like, so I'm not badly off after all. So for me, health it's all about making sure that you stay alert and you're able to give your best. And that's why I talked about mental health earlier. Because with alcoholism, you begin to lose not only part of your appearance, but even your mind. Because every single time you have a challenge, instead of thinking about the solution, you first take 1-2 bottles, and that becomes the solution. But the problem is not going anywhere. The problem has stayed. And if you do that consistently, it's a matter of time before either the client or your colleagues realize that you're not a solution person, you're just someone who keeps pushing it back. At the end of the day, for me, if you fall sick, and then imagine, and I keep telling my colleagues that imagine one day you're there, and they say, Meta needs A, B, C, D, and the liver transplant. And the first tweet from someone is like, the alcohol has caught up with him. You might not even accept the money the guys are going to give you for going for that transplant, because then you only have yourself to blame. But being healthy, I think, should not be something that we can negotiate about. We've had discussions in different forums about our health facilities in Uganda. So you would not want to have complications which are related. They are lifestyle diseases. Yesterday, I was talking to a magistrate, and he tells me all judicial officers have back problems. All of them. And there are some young ones I've seen, recently appointed, they now wear those waist corsets. And you wonder, man is not even 35. And he's already now, tying himself like those old women of the 50s and 60s who are wearing those tight dresses. Because of the lifestyle. You sit from 8 a.m. to around 4 p.m. You're in the same chair. You wake up, you're so tired, the mind is tired. But because you don't have the practice of fitness, you end up going to maybe sleep. You wake up, you drink 1-2 bottles of wine, you wake up back to the same routine. And he made a funny statement and said, there's no judicial officer who retires and stays alive for more than 10 years. He says they all die within 10 years. I don't know how statistically correct that is. That is alarming. But for me, it's a health-related issue because of the lifestyle that we have. So lawyers were privileged to have money in certain instances, so we don't need to waste it on drinking. We should be able to have serious use for our money beyond drinking. Drinking is not bad, but I think people need to know their limits. If your limit is 2 bottles, once you clock your 2 bottles, stop there. Don't take it out on the bottle that I have a crate that I must finish. That is not really how life is. We must prioritize fitness. Me, I go to the gym 3-5 times a week, Monday to Friday. I only rest on Saturday and Sunday, if time allows. Today I've not gone, tomorrow definitely I'm there. Then maybe I'll compensate on Saturday for the loss of today. Because for me, it is now part of me, it's stuck in my head. So the same way the alcohol routine is stuck on the heads of some people, fitness can also replace it. Because at the end of the day, if you go to a lot of gyms, you find people who are really, it's telling you that now you see I'm coming back. But you can see the pain they have to go through to get to what, especially the ladies. There are ladies who will show you their photos. When they're in LDC, Joy is here, and she will show you a photo of when she was in LDC. And you see the person who's showing you the photo, and you're asking, is that your daughter? Why? Because now you've lost shape. You're totally, I'm not saying, shape should be there forever, but there is a legitimate expectation that you should look a particular way. especially for ladies. You can't look like Beyonce in LDC and then in 2 years of practice, you look past full figure. There's a serious issue. You can't be the same person. So it's all about looking after yourself. Okay? So it's important for us to be able to keep fit, but also it keeps your mind alert. That's the honest truth. I think if you ask anyone who works out like in the morning, they will tell you after working out, they feel fresh, they feel alert, they feel, they are ready for something. So I think it's important that, we do it. But also my brother Nicholas, I don't know what weight loss program he's on. He has always looked the same. I've never seen Nicholas adding a kilo or losing it. I think it's like Jose Chameleon. He doesn't get fat, doesn't lose weight. So I think he should also share his secrets with us someday. Thank you.
Yeah, thank you, Mr. Meta. Today you have not gone to the gym, but at least for us, we have gone to the gym. Our brains have gone to the gym because you exercise in courtesy of the knowledge you're sharing with us. So as we have not gone to the gym, for us, our brains are in the gym, and we appreciate you for that. When you're exploring, maybe as I got my next question, when you're exploring the employment opportunities for several young lawyers which they can take on, what was on my mind then was what skills those young lawyers need to build so that by the time they reach this end, they can take on those several employment opportunities, because we all know the law teaches the theory part, the law teaches procedure, but then the market demands more. And then from your experience as a practitioner, as a managing partner, as a lecturer, what are those essential skills that a young lawyer must intentionally build today to truly thrive once they cross from LDC to practice or to the job market, which has several things they can explore as we hinted on them? So, and you watch to the young lawyers who are online now, what should they be working on beyond the classroom, beyond the back course, to ensure that they are not just qualified with the papers, but they're actually competent, competitive, and adaptable to the real world of practice once they come out of the center or out of law school? Thank you.
Thank you, Alfred. Skill is intentional. First of all, you have to know what you want. If you're going to play golf, if you're going to become a professional golf player, you have to go and practice. You have to learn how to swing. You have to learn how, even you have to learn how to wear shorts and a cape. If you have bad legs, you have no business playing golf because most of them are wearing shorts. Okay? So it's a skill. Look at tennis. I've never seen a lady who weighs more than 80 kilos playing golf. Sorry, tennis. They're all, so they build towards something. Even the skill of swinging the racket is different. Look at the basketball players. It's all about practice. Now, if you also look at our profession, that is why it was important for you to work under a skilled and senior colleague in the profession to be guided. That's where the skill will be developed. At the Law Development Center, we can only be able to introduce you to theoretical procedure, because it's so difficult for you to recreate the courtroom. We have the moot sessions, yes, but there's so much that is different. And I always tell the students, when I'm a moot judge, I tell them, LDC is the best judicial practice area in the whole country, because you get the client on Monday, and by Thursday you have a decision, because you're going to have moot, and your papers are filed on Tuesday, Wednesday you exchange, Thursday you're in moot, your case is heard, both parties are heard, the matter concluded.
There's no backlog.
When you come out here, there's no backlog. I agree with you. When you come out in real life, you will realize that even just getting a date in some courts is close to impossible. Now, if that is the world that we are telling you about, and you come out the practical world, it's as if you didn't learn anything. We tell you to be ethical and say, don't bribe. And then you reach and the clerk tells you, you want a date? The nearest date is in July. And all he wants is 20,000 shillings. And the moment you give it, either by luck or maybe you're just saying thank you for giving me July, and say, by the way, hey, thank you so much for giving the money, but since you've given me money, I can get you a date in Feb. So it gets into your head that to get a closer date, you need to have to bribe. We don't teach you that at LDC, but in real life, that is the truth. So
It's good you don't teach that.
The skill becomes, but you see, then when you get out in practice, then you start questioning that, but why did these guys teach me? So for me, the skill, the skill is, which we need to look at, is being able to deliver. And that can only be done if we were able to have these students have a practical feel of what it is like. For example, if you look at, which we had a change, which I think was for the better. In the past few years, we used to have term 1, term 2, term 3, then the students would go for clerkship. And then they don't come back. Now we have term 1, term 2, after orals, they go for clerkship, then they come back. The idea is that by the time they return to 4th term, they now have a practical feel for it. But I also know there are some universities that send students to go and do clerkship right from, I think, 2nd year in the universities. That, for me, I think is a good approach. Although the problem is, can the law firms contain the numbers? The law firms will be packed all the time if we are to do that. But that is the only way to practically train. The skill of comprehension is something that should have been learned when someone was doing literature. When you read a book, you should be able to summarize the book. One of the things in LDC is brief facts. You read, they tell you, summarize the brief facts. That is a skill that you should have learned right from primary school, secondary school, so that you're able to summarize a story. Now, that is comprehension. You can only understand and summarize after you appreciate all the factors. So I think students, to develop that kind of skill, must love to read. That's why I talked about the earlier issue that you find someone has never read a full case. It's a locus classicus, he has quoted it from first year, but he has never read it. And those who are listening, have a personal self, introspection. Ask yourself that, how many cases have I read this year alone, fully? That I've read a full case. How many of you? Ask yourself. Don't tell us the answer, but you know. Now, that means that skill of comprehension, you're not developing it. Then you have the skill of synthesis. Synthesis is basically knowledge-based. So the knowledge really must be there. And I tell people that all these things that we know are done by humans. Even the Chief Justice of Uganda was once in P1. And I don't think at that point in time, in his wildest dreams, he knew that he would become the CJ. But one thing led to another, another thing led to another. He kept pushing and kept pushing. He's now the CJ. One of you here listening today will one day be a minister. You'll have to take a docket somewhere. As a lawyer, in that docket, we expect you to demonstrate certain skills which are only a preserve of lawyers. And understanding, comprehension is one of them. Communication is a key skill. But to me, Alfred, the short answer to this is, for us to properly skill, there must be some element of mentorship. There must be that close relationship you have. But the challenge is, because when you go into clerkship, you find that you apply to the places that you would want to go and do clerkship in, and you're not taken. So you end up in DPP. Yet your preference is corporate and commercial practice. So you're going to be doing cases of rape, murder, defilement, theft, and perusing those files. Yet for you, your interest is maybe commercial transactions. But the law firm you applied to, maybe 15 people applied, and they only have a space for 3 or 4. So that becomes a challenge, and it is now incumbent upon you to find other ways where you're able to push yourself and say, I am going to try and learn corporate and commercial practice from so and so. So LDC may not be able to give you all that, but LDC is as practical as it comes. But then, lastly, the students should be able to seek out the lecturers. At least in my time at LDC, I've had, I think, about 10, 15 students who have come to me straight from term 1. Say, I would like you to mentor me. And they keep inboxing me throughout. Some of them, you go and teach in Mbarara and they ask you. You're in Kampala, but they're chatting with you every single week. When they have a problem, they're asking you, there's this problem question, I'm trying to approach it. We have had a discussion. How is this? I feel that goes a particular way. But also, if you look at some of the colleagues at Law Development Center, I think guys like Mr. Wambuga, who is the assistant director of, he insists that, as a lecturer, when you go and visit his campus, give time to the students to consult you. But other students don't understand why they should come and consult. Most of them come and consult, about just workshops, but they're not developing themselves fully. Maybe one thing we need to do, I think the legal aid clinic is also there. I feel those guys have a better skills development in that sector than the mainstream corporate, land, civil, and criminal areas. Maybe the moots that we do, which are supposed to be, for example, you have a moot in corporate and commercial, and it's about litigation still. Why don't we sit and negotiate contracts? In a contract week, you're litigating. What are you litigating? Have a session where students sit and they negotiate a contract so they can know how a contract is negotiated. So for me, skills can only be developed to suit the market. The market keeps changing, but the constant is one, you must have the knowledge. Two, you must be able to appreciate the area of the law you're advising on. That's why I said you can be a jack of all trades and a master of none. You must be able to know that this is the area. Even in your law firms, you know that if you have a particular problem, there's a particular partner you'll go to. You don't go to, there is one who you'll not go to because his field is different. So the same thing is going to be with your skills development. And then, of course, lastly, there must be someone who is trainable in you. If you're a rigid fellow and you believe that you know it all, then regardless of what advice you get, you'll never succeed. Look at footballers. Cristiano Ronaldo is older than Wayne Rooney. But because Wayne Rooney has the same problem with alcohol, he now looks like Ronaldo's father. And Ronaldo is still playing. Okay? He now looks like Ronaldo's father and he's still playing. Look at the great Brazilian footballers like Robinho. Because they are not trainable, he's now in jail in Brazil for rape. Yet his peers who played with him have been revered as serious people. Look at a guy like Ronaldinho. He was touted to be the greatest footballer of all time, skill-wise. But because he was not trainable in terms of discipline, he's gone. So skill can only be built on someone who has discipline and is willing to learn. So that is where everyone should be. Tell yourself that you're willing to learn, and then you learn. Thank you.
Okay, thank you. If you're just joining us, we are about to wind up the Judicial Service Conversations. We've shot up 11 minutes more than the time that we had. I'm listening to these stories. They are very interesting, and I'm remembering some mentorship stories. A man was asked to mentor a lawyer, and the issue, I think an issue came up of abandonment, and he called it the principle of abandonment in criminal law. And this fellow said, what are you talking about? The mentee asked him, what are you talking about? He said, for example, if you leave money there, you find $1 million shillings and you pick it, what is the legal ramification? And this other fellow told him, so when you talk about a mentorship, I remember another time when a friend of mine who I'm seeing online here was cracking with someone, and the lawyer told him, now what you do, we go to court, you write, you take notes, but just don't write the questions, just write the answers. So the fellow starts cross-examining. You joined police on the 4th of June 1990. He said yes. You went and you worked in Mbale. He said yes. You proceeded from Mbale, you went to Jinja. He said yes. You then left Jinja, you went where? He said yes. And all that time he said yes. So after ending the case, when he went to check the notes, the man had written yes, 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 yes. So maybe let me hand over to Joy to ask the next question. So, but the point I'm making is, the serious point is that even mentors need mentorship.
That's definitely true. Mentors need mentorship, and that is some of the, I think that's largely part of the work that I'm finding myself doing. We'll get into that, but I just wanted to check out some of the comments to acknowledge our listeners for tonight. DK, you say technology bridges the training practice gap by giving students practical exposure to digital research tools, virtual court sessions, AI-assisted drafting, and online mentorship. helping them gain real-world skills before joining legal practice. That's very true. And you had a question about how technology can be used to equip students with the practical skills they need before entering legal practice. I feel like probably counsel could have covered that, unless he feels like there's something he could add on that. And then Emmanuel said nobody can stop reggae. Counsel Meta, so practical and hand skill. Okay, maybe skills on, I don't know. Gumisiriza, you're saying, for example, I will not read that, but we see you. Daniel, you're saying to all advocates our country is in need of good judicial service delivery. This will start with you being a good lawyer who upholds the laws in our country with no shortcuts to victory in winning a case. May God guide you in this endeavor. Good luck with your upcoming exams. That was a nice one. Raphael, you're saying for employment issue, young lawyers should embrace innovation and value addition. You can mix real estate law with land law, build a website for international markets, and build your brand. That's a good one. Morgan is saying he's representing the practical law students. Okay, Mr. President, we see you. Daniel said loud and clear. Musoke, you're saying it's a timely conversation. Isaac, you said alcoholism is a mental health problem ab initio. Okay, I think that's some of it. We can't read all of them, but we just want to acknowledge your presence and say thank you for being a part of today's Judicial Service Commission conversations. Now, Council Meta, the other bit I think you've hinted on and we've been bantering about it is mentorship. So I would like you to give us some advice when it comes to professionalism, when it comes to reputation, and the essence of good mentorship as a young lawyer who has just come out. Because I think as at LDC, I was mentored by that gentleman over there who was list, Council Alfred. So he's been my mentor, and then I think over time I'm finding myself in that space of mentorship. I'm realizing that the biggest problem the young lawyers are finding is they don't know, first of all, they don't know what mentorship is. The word sounds good to say, I have a mentor. I go and take a photo with Council Meta, it looks good, I have likes, so you just throw around the word and say, he's my mentor. But what is mentorship? What does it look like? What should a mentee do? And should they just go about and say, this is the person I like, but like, what are those things that someone should look out for in a mentor? So how to do the mentor-mentee relationship. So just in brief, professionalism, reputation, and the essence of good mentorship. Thank you, Council. Over to you.
Thank you, Joy. Professionalism. I think professionalism really is an area that we all understand, so I'll not really say much about it. This is basically behaving in accordance with the expected standards of an advocate. There are those minimum standards. We may not like it, but our decorum and how we behave and how we communicate is something we must be able to all accept, that there's a level that should be espoused by an advocate, that this is an advocate. It starts from your dress code. Okay? I would have preferred to come here in a vest because it is my evening, but because we are having a law and professional discussion, I must look like one. I must not look like I'm going to, be a bouncer for Bebe Cool. Okay? So that could maybe be a side hustle, but not, that is unprofessional. So your dress code is important, and that's why even at the bar course, there's a uniform dress code that students should accept. Okay? You may not like a tie, you may not like a jacket, but you have no choice. You chose the profession. You must look like that. Otherwise, we may not differentiate you with Sentongo, who is selling G-nuts at LDC. For those of you who know Sentongo, is part of the fixture at LDC. Reputation, this is really an important one. I have a colleague who used to say character is what you're in the dark. When they switch off the lights and you start picking your nose and, and doing, some ritual dances, that is your character. Not the one that you show people out here. So reputation really is a very difficult thing to gauge, because it can only be known by those who are close to you and who have dealt with you. Now, if you're going to choose a mentor, you must be able to consult, but it's very difficult to consult. But there must be someone who has been recommended to you by another person. Otherwise, as they say, even fools grow old. You end up with someone who is totally not cut for it, and is the one who is guiding you. And that's when you start hearing statements like, do as I say, not as I do. So there you'll have a problem, you'll have a conflict. But mentorship is a very interesting word, like you've said. This is really, for me, the meaning is that you are trying to emulate someone. You are trying to reach a certain level of professional development that you believe that person has achieved, and you'd want to walk that journey with that person. You'd want to be guided in terms of how to grow in the profession. You want to be guided in terms of how to behave in the profession, but also how to make money in the profession. So if you met someone who makes money in a crooked way, he will mentor you, and you will be mentored into the next generation crook. So mentorship is two ways. It doesn't mean that when you have a mentor, it's a good thing. It could also be a bad thing. And that's why I said fools grow old as well. The guy will have experience, but his experience will be negative. But the idea behind mentorship is that you're supposed to properly and professionally guide someone to let them achieve their potential in that particular field. So to get a proper mentor, you need to have someone who sees potential in you, someone who has the ability to train you. We have people who don't have that ability. They don't have the patience. A mentor must have patience, because you're going to make mistakes. You're learning. And he should be able to have the tongue to guide you, not to scold you. There are people who don't respond well. There's one thing we've talked all evening, which we've not really highlighted nowadays, is a whole talk about Gen Zs. That there's this new breed of people who have dropped from I don't know which planet. I don't know, Jupiter, I don't know, Mars. They are called Gen Z. And by their very description, they're untouchable. That if you just poke them like this, you might have a whole army of young, small people running around you, throwing stones. So that thinking process is also getting into the profession. In 10 years, we're going to have judges who are Gen Z. And we shall have to appear before them.
Yes.
And the guy will be there with these dreadlocks and earrings, and there's nothing you're going to say about it. I think you remember the former CJ in Kenya who had his dreads. You go there and you say, the judge is a Rasta. The world is becoming more acceptable. But when you talk about mentorship, get someone whose ideals rhyme with the profession. Someone whose competence is not questioned. We all have mistakes. Let's not lie that we are perfect. There's no one who is perfect. Unless, of course, you've lied to the level of convincing yourself that you've never made a mistake. Everyone makes mistakes. But there are those who make more mistakes than others. And their mistakes are so blunt that we say they don't have manners. So the yardstick for a good mentor should be someone, one, who listens. Two, who is able to develop. Three, someone who is able to teach you the ideals of the profession. If you can't get that in a particular person, then you don't even have to go to the fourth, which is time. The person should have time for you, because you can't mentor someone by osmosis. Maybe just to take one thing to using technology for education, I agree that we can use tech. And I think in some instances I've had discussions with colleagues and I've said, why don't we have, for example, at LDC we are doing moots. Why don't we have one of these young computer experts develop something similar to an ecosystem of ICMIS, so that students file on ICMIS at LDC. How expensive is that to develop? Then you can have virtual hearings. I don't have to go to the center. Then I sit in my chambers. Then maybe senior colleagues like ELISON KARUGANGA would be able to volunteer, sit in his chambers and rate these students for us. Because I can't teach, then I'm the one assessing. Then maybe the student becomes complacent. But if you can be able to work with technology, I think it would really go far. We have to have a totally different conversation in terms of how to use technology to educate our next generation of lawyers. Thank you.
Okay. Okay.
Before you ask your final question.
Oh, if you're just joining us, welcome to Judicial Service Conversations. I've seen that a mentor should have the ability to listen, to develop, to have, he must have time, and I can see someone who is always patient, who has time for us, who is able to develop, and that is the Vice President of the Uganda Law Society, who has been listening to you since, and so I salute him really. I know he's mentoring many people, and when I had all these skills, he also mentors at LDC. So, Mr. Vice President, you are very welcome. I think Alfred has a question. We want to start winding up.
Yeah, thank you. I have one question, and it's, I think, from someone whom Mr. Meta mentors. It's called Stephen Isaac Musede. I hope I pronounced the name right. Says that you were practical inspirer in the legal space. You mentored him well, and is on the meta list. He confirmed that, and he requested that you talk about how to build a brand. I think that's the last question before we get to this. How to build a brand. Yes.
Thank you, Isaac. How to build a brand. A brand is one of the most difficult things to build. But I think the only thing you can rely on to build a brand is quality. If you can offer quality, exceptional quality, you have a clear-cut niche and you have a clear-cut target, then you are on your right trajectory of building a brand. You need to have integrity, you need to be honest. But competence is important. You should have a competent team. So if you're going to build a brand in Uganda for a law firm, you must have a good team. You must be able to deliver quality. That is really what will set you apart. There's a reason why people drink a particular brand of soda over another. There's a reason people watch a particular TV station over another. It comes down to what the perceived quality. So you should be able to rise above your peers. If you're going to build a brand, for example, in Uganda today, there are certain law firms that you must be able to measure up to. If your target is a law firm that is in Maracha, there's no law firm in Maracha. If your target is to compete with a law firm in Maracha, or in Ajumani, or a law firm in Kotido, which has one partner, he's the managing partner, he's the employee, he's the secretary, he's the clerk, he's the one who goes to court, he's the one who does transactions, he's the one who does locus visits, he's the one who serves, then you don't really have much of a target to defeat that. But if you want to compete with the likes of KAA in Uganda, then it starts with building a team. Identify where you're going to be good at. Once you have the area, your target, then you know, I have my team. Then have a relentless pursuit to develop the talent. Because the mistake I see with a lot of law firms is you hire a brilliant fellow and you don't invest in his or her education. But maybe it's because some of them, once they also feel they're big enough, they want to run away. So that is where the balance has to be struck. You have to have a relentless pursuit to develop yourself, to do the futuristic things. And I think when we started this conversation, one of the questions my senior brother put to me was that, what does a futuristic modern law firm, how do you do, what do you do? That is really where you begin thinking of a brand. I think the word brand should not be used for certain products that are below an acceptable minimum product level. So even in the law firm, there is services you're selling. So compare yourselves to institutions that are doing services. For example, if you look at telecoms, MTN has a service, Airtel has a service. Are you going to go for another one? There's now all these fiber services. The one that does not connect very well every day, by the end of the month, you're not going to connect there. Their quality is not matching what you expect. So the same thing, if you're going to practice as a lawyer and you're not giving your client solutions and backing them up and making sure that they always succeed, if you lose more than winning, regardless of the situation, then you don't have a brand. And chances are very high, when another alternative arrives on the market, you'll be gone. So I think brand, Isaac, quality. Make yourself the best version of you and target to be the best in that particular field or among the best. Then you can talk of having a brand. Then people will come to you, people will look for you. You don't have to look for clients at that particular point in time. Thank you.
Thank you. If you're just joining us, welcome to the Judicial Service Conversations. I can confidently inform you that you're late. We are right now starting to wind up the conversation. And I mean, I had you talked about the brand, but you've also talked about the lawyer and the ethical practices of lawyers and the relationship between how lawyers should relate to the bench and the future bench. And you know, I just remember two very quick stories. One is a criminal session somewhere in this country. So those who don't know, some of our trials are conducted by criminal sessions, and there was one prosecutor who was trying about 40 matters before the same judge, and every single case the prosecutor was making very glaring mistakes in the view of the judge. And so at the end of the session, and throughout the session, in each case they had a very testy exchange. So at the end of the criminal session, the judge gave an order, told the prosecutor that for the remainder of your natural life, you are banned from appearing before me. To which the prosecutor responded, I am much obliged, my lord. Even me, I don't want to appear before you for the remainder of my natural life. And another time is when a senior advocate, whose name I will not mention, appeared in the Court of Appeal on a matter of a contract. And he told the judges that for there to be a contract, there must be offer, there must be acceptance, there must be... He began mentioning the elementary principles of contract law. After 20 minutes of his presentation, he was almost as if in the first day of the first year contract law class. And a senior judge told him, counsel, can you get to the point of the appeal? He said, no, I'm first laying a background, my lord. And the judge told him, counsel, can you credit this court with some intelligence? We have a basic understanding of contract law. Please don't insult us, go straight to the point. And the lawyer said, with respect, my lord, that's the mistake I made in the lower court. I don't plan I don't plan on repeating it. So when you talk about the future lawyer, the earring, those sort of things, I think these stories come to mind because they're telling you about the testy relationship sometimes you have from the bar and from the bench. But you said something which I think is lost on so many people. You said many judges after retirement die and within 10 years of retirement, and that statistically speaking, the vast majority of judicial officers have back problems. Justice Bamwine, retired principal judge, was actually sitting where you're sitting on these judicial service conversations, and he told us that in his time he used to record longhand, and a point reached where he could no longer write. We have judges who are, you go to the court, there are some judges, particular judges, who have to use laptops because they actually have now a problem writing, not because they are highly technologically savvy, but because they can't actually hold pens because of the nature of work. And we have been arguing in these judicial service conversations that part of the problem is the workload we are imposing as a country on the men and women who volunteer themselves as judicial officers. And these men and women who volunteer themselves as judicial officers are handling dockets of 1,000 cases. In Masaka recently, a judge had to go and study, and because she had to go and study, another judge had to take on almost 5,000 cases, which became almost impractical, and the Masaka bar had to strike. In Gulu, in Mbarara, in Kabale, in many places in this country, judges in the civil division of the High Court, in the land division of the High Court, judges are sitting on 1,000 case dockets. 1,000 cases, 1,500 cases, you find one individual. A judge, someone gets appointed, a judge, the family goes to church, they thank God, they've been appointed, there's been a new appointment, there's a Thanksgiving ceremony, people come and praise the fellow goes to his new assignment, fire in his belly, hunger in his heart, justice towards all. He sits down and they give him 1,000 files, and then he doesn't know where he has to start from. And as a result of this, we have been arguing that actually there is no reason why we should. The judges don't become efficient because of it, but they work from, and you explained it well. If the statistic is that a large number of judicial officers have a back problem, it's not because they don't have time to go and work out. It is simply because from the moment they wake up to 6 p.m., they are listening to people. From 6 p.m. up to 9 p.m., they are reading. From 9 p.m. up to midnight, they are probably writing in order to handle this backlog. And then he comes back. You know, I know a judge who has been asking parties to finish a case for 2 years. You guys, I need you people to finish, and people still have evidence they want to bring. So one of the solutions we have proposed is, and I'll ask this question very briefly, is mission-based judges. And we are saying, why don't we have an attack on the problem of backlog? It's growing. Every year it's growing. More and more, the population is growing. There's a population explosion happening. Transactions are exploding. When I joined practice, the economy of Uganda was about $20 billion. It's now about $60 or $70 billion. I think I don't have the actual figure. Yeah, the transactions are growing. The population is growing. The population was about what? In the 1990s, it was about 17 million people. Today, it's about coming to 50 million people. So you have population growth. That means a lot of men are being taken to family courts to look after their children. More, you have people dying, and you have estate issues. You saw the expansion in the estate management. Our argument is that the judiciary, as currently structured, is unsustainable for the public, is unsustainable for our businesses, and is completely unsustainable for the people who are serving as judicial officers. And the solution is, let's give them support. Get in their mission-based judges with a mission to actually eradicate the backlog. We had a donor here, I think the chairperson of the justice, who said that Uganda needs to think about not reducing backlog. We don't need any more backlog reduction programs. We need to sit and say, in a year, what do we need to eradicate the backlog? And so, I don't know what your take is on mission-based judges. It's a traditional question we ask everyone who comes here, and we don't expect them to answer it in a particular way. So please feel free to express your opinion.
Okay, this is a tricky one, but I think it is in context with our practice. We all accept that there's a problem with backlog, how cases are handled. The competence and professionalism not even withstanding. We have so many cases, and if you look at our land judges and judicial officers, to give someone 1,000 cases, that is demoralizing to a level where you might even want to resign or retire before even your first salary. But pride might be too much for you to say no. So you end up taking the job, and I believe you just do what you want to do. Just do what you can do. I think I agree with you to the extent that there's no way the numbers are going to drop. I think more cases are filed every year than judgments given. There are more pleadings that have been filed, and even you should also credit LDC with part of it, because we are churning out as many lawyers as possible. And that means there's more advisory being given at different levels, notwithstanding the merits of the advice, but more people have access to lawyers, and every dispute can now be litigated. And if you then look at the population growth, the population is not about to drop unless we do the one-child policy of Kenya, and they say if you have twins, you choose one, and we try and lower the number. So the Nalongos, I don't know what they will say to that, but I think one of the solutions is what you're proposing. If we can have appointments that are targeted, because indirectly the judiciary is already doing that with the so-called sessions. When they pick 2 judges from Kampala and say, let's go to Arua and try to do it. But what you're not realizing is that the two you picked from Kampala have left their backlog in Kampala. So whereas you're trying to fix one in Arua, yours are still increasing this side. When you come back, the 1,000 you left are still there. So unless we blow the numbers of the judges permanently up, which might be unsustainable on the economy and the money, but if you could have persons appointed, say, go there 3 years, your duty is to ensure that you clear 500 or you clear 50, you clear whatever. That might be the practical solution, because at the end of the day, whether we like it or not, I think let's try and audit the Chief Justice statistically. When he took over, how many cases were there for backlog? When he's going to retire, how many cases are still there? What interventions did he put in, and why didn't they work? Or why did they work if they are successful? Then we're able to develop empirical evidence in terms of how backlog has been handled and why we have failed to handle it. Because at the end of the day, the solution is really on the wall, that you need more ears to sit somewhere and hear these cases. But also we can improve in terms of weeding out the, because see, some of these judges also bring their own problems. They shoot themselves in the foot. We've had the famous one who was sometime in Arua, and he would hear bail applications and adjourn rulings for 3 months. Bail. Whether someone has sureties or not. Do you need 3 months to go and see whether the sureties are substantial? Now, such a fellow, I don't know what the Judicial Service Commission is doing and what type of reports they get on these guys. But for me, I would think that is one area to begin. But even our civil procedure, that you apply for a temporary, then you apply for an interim, all that is just clogging the system. If a judge sees merit, let's have an injunction, maintain the status quo, preserve the property, and then hear the case. But it is also economically unviable for us that you have a judicial system where the commercial division of the High Court had been put there to try and handle matters expeditiously. But now you hear stories of cases which are 5 years old, 10 years old in the commercial division. So it has lost the meaning as well. But also placement of these officers, you appoint someone who was a public prosecutor, and you throw them in a division where they have to handle something which is totally unrelated to their former practice.
Sure is.
Then you have a problem. But we have enough guys here. I think one of the areas which really has a lot of people practicing is land. A lot of lawyers do land transactions, and we have a lot of senior fellows. So if you had mission-based judges, that is one of the areas that could benefit a lot. And that is why our biggest issue, I think, with backlog, land-related, and which ties down development as well. So it has a knock-on effect. So I think proposals as mission-based judges should not be proposals that you're going to fight. These should become part and parcel of what help to resolve the problem. Because at the end of the day, we all know the problem of backlog is not about to go anywhere. It is just like wishful thinking. It's like an ostrich that buries its head in the sand, thinking because it's not seeing you, the rest of its body, which is outside, cannot be seen. It's absolutely laughable, because I don't think in the last 10 years we've developed any robust enough solution to handle backlog. And in the next 15 years, the cases are going to more than triple. I think the judiciary needs to do a proper statistical analysis of how cases have grown year on year vis-a-vis the population and the nature of disputes that are arising. Because for me, all I see is more disputes and more disputes and more disputes. And it means you need to either hear cases quicker, or you need more people to hear those cases. And if you can't have the more people permanently, then get the serial assassins who are just going there to assassinate the backlog, and they move on. It should not be something that is fought. I think you can't have one solution for fighting backlog. You should have a multi-pronged approach in terms of how you're going to attack backlog. We can fight it on the front of LDC by trying to have better lawyers who are going to file serious pleadings and they only file serious issues. But we can also fight in the time of reforms where the laws allow for a speedy trial and things like that. But then even the personnel, that what you're really suggesting is that we should have people who are going there to attack this problem. That should be another angle. I think if all these forces are put together, then it is easier for you to be able to reduce backlog. But I don't think in our lifetime, me and you as practitioners, we are going to reach a level where judges are going to reduce backlog to a bare minimum. I think Justice Mubiru almost pulled it off in Arua, and it was because it was very, very strict. Unnecessary adjournments were not allowed. You come to court, you adjourn. What law are you using to adjourn? Costs on counsel. So people started coming to court prepared to listen to their matters. And he did a good job. He really, really lowered it. But how many, you have a friend who is a judge who said, you know, when you hear cases that much, you begin growing old. That one day you'll stand before the mirror and you say, but is this really me? Why? Because you're tired. And because you're done. And all you can then do is wish you're taken to a court where there is no work. Of course, which court doesn't have work? All courts are now packed with a lot of work. So, a multi-pronged approach and appointment of additional, helping hands should be something that really the judiciary should be advocating for, to ensure that they can also have a life outside the judiciary. Because if you make money and you don't enjoy it, then it is useless. People will fight for that estate when you're gone. So you have to enjoy part of it. So you must also have time to enjoy it. That's what I would think.
Okay, thank you. And now to our final question. First of all, I want to thank you really for that very elaborate endorsement of this proposal. But now our final question. We've overshot your time here by 45 minutes, and I think the audience has kept going up, and the discussion has been fantastic. So we want to thank you for coming here. And the final question we ask you is just to give us your parting shots.
My parting shots. Thank you to the co-hosts who have welcomed me here warmly. Joy and Alfred, you've fired me your questions. I hope I have done justice to them. But I'd also want to give a big endorsement to you, my senior brother, ELISON KARUGANGA, for having given us this space to have this interaction. I think these are initiatives that really broaden our practice, but also, in my opinion, very, very futuristic. If you look at our practice in Uganda, this is really a different angle of looking at things. So there's a lot of knowledge shared here at a level where maybe we may not have access. A lot of lawyers in Uganda don't write. I encourage you guys who are listening, you need to write books. If you go to Aristoc booklets, there are more Kenyan authors than Ugandan authors. Yet we also have our own practice here. We are still relying on, jurisprudence and books from, Kenya, from Europe. Yet we have people here who should be able to write. And writing doesn't need age. Even you, the young ones, as long as you have a topic where you can write, you must take the lead. But with all sincerity, I thank you for this platform, for incorporating the young lawyers in this particular discussion, especially those who are going to do their final bar exams. I thank you, the members who have joined. To the young ones who are present, I wish you the very best of luck. All the tips we've given you are for guiding you not only to pass the bar course, but also to develop. And I would urge you to always try and listen in and follow these discussions. They're always there on Wednesdays. Let's try and learn, because one way of becoming better is by listening to experiences and other colleagues and having discussions with them. And I hope you've learned something, one or two from me. And ELISON, again, thank you. And the entire crew, thank you all, and I wish you all a good night.
Thank you, Meta. If you're just joining us, you're late. Welcome to the Judicial Service Conversations. We have had a fascinating conversation with Meta himself, Mr. Emmanuel Meta Aloro, the man of Meta's list. And if you are not on that list, you had better be on the director's list. And if you are not on that list of the director's list, then you shall have the blessed opportunity of doing LDC again. Our guest today, ladies and gentlemen, has been fantastic. Meta has reminded us that the strength of our justice system isn't in our statutes or in our buildings, but is in the caliber of the lawyers that we train. It is in the standards that we uphold. It is in our conversations with each other. It is the fact that for many of us it is a career, and for many of us it is also a calling. I think the passion with which he teaches and the passion with which we've been able to discuss these issues, he has told us we have basically seen what happens when skill meets service and when knowledge becomes legacy. So we have better learn from him to prepare better, to serve better, to lead better. For the BACO students struggling with research, he has reminded us that that BACO student is very easily tomorrow's Chief Justice. And so we must oblige that lordship right now. To the young lawyer learning the ropes of the courtroom, he has reminded us that that young lawyer, whatever academic knowledge he got was foundational. He has reminded us that the future of our profession is not built in classrooms, but it is built in our chambers and courts every day. And so, from us at Judicial Service Conversations, we are grateful to you, Meta. We are grateful for the opportunity you've given us and for the time you've given us. To the many bar course students who are out there, some listening, some not, it has some of us dinosaurs have come to realize that you have exams soon. I noticed that from the questions that Joy and Alfred keep insisting that they are young lawyers, and Alfred is a big man among young lawyers. He's the Secretary General of the East African Law Society, the Deputy Secretary General of the East African Law Society, in charge of all young lawyers in East Africa. So I don't know if that makes him the youngest lawyer. He's already a mentor. So they keep, so I discovered from them in the questions we're having today that actually people have exams. I think I confirmed now that I'm a dinosaur. But allow me on behalf of my fellow young lawyers, and also on behalf of these young lawyers, to really wish all the best to those people who have the challenge of sitting for the BACOS exam. When we were in school, we used to read Glanville Williams' Learning the Law. I don't know if they still read that book now. And he said somewhere that exams are a formidable foe, because even the dumbest man can ask more than the wisest man can answer. Fortunately for the students at LDC, you have seen the caliber of the people who are asking you questions. I don't know if that is fortunate or even more more unfortunate. But good luck. To Meta, thank you so much. Thank you. We thank you for being a great leader, for being a good teacher, and for being a practitioner of depth and conviction. To those joining the Judicial Service Conversations, we are still here, as we always are, every week with the struggles that we always fight. But conversations like these give us hope and give us energy. They reignite us. They recharge us, because in the vast ocean of the bar, there are stars that are shining bright. In the dark night, there are still bright shining stars. In the early morning, there is still the daybreak and sunlight. From Judicial Service Conversations, to everybody who has joined us, thank you for joining us. Meta, what happens here usually, I'm sure you are aware, owing to public demand, really, and public demand only. There is a song that is played. DJ Alfred plays a song that is in tune with this Judicial Service Commission election that has never come. We have this election which is like that was it, that legend we used to do. It was not a legend. What they used to call them? The three brothers who were sharing milk in a pot. And the whole night they spent it pouring this milk in a pot. That's what's happening here. We're almost always about to vote, but we believe that nobody can stop reggae. But the song which we play at this juncture is really an election song. It wasn't never into, and recently, and this is, you can check this. You can check. Anybody can check this. Recently, the mayor of New York was copying our song, and it was, I think, because he was also supporting us. But whatever the case may be, this song is a song about our election, and certainly it's about me, and we are going to play it shortly, but and you'll hear it. But ladies and gentlemen, if you're just joining us, from wherever you're joining us from coast to coast and around the world, from us at Judicial Service Conversations to you, it is good morning, good afternoon, good evening, and good night. And now, the song.
Short note, as if they came on short notes.
So
They came on short
trying
notes.
to be on Meta's list.
They came on short notes.
Wow. But it was interesting.
I will do you.